The concept of res judicata evolved from the British common law system. Many jurists believed that the concept existed in the Roman legal system. The concept of res judicata existed and prevailed in India in the name of Purva Naya. From the English common law, res judicata flowed to the Code of Civil Procedure to the Indian legal system. In the 7th Amendment of the American Constitution, the concept of res judicata originated. In Roman law, the concept behind the res judicata based on the three Roman maxims. 1. Res judicata pro veritate occipitur, means decision of a suit is final. 2. Nemo debet lis faxari pro idem causa, means no man to be harassed twice for the same issue. And 3rd, interest republicia ut sit finis litium, means must be end of litigation. In concise of the three maxims, we may say one suit, one decision for a single dispute. One of the earliest judicial pronouncements on res judicata was the case of Duchess of Kingston in 1776, where Justice Sir William de Grey observed that the judgment of a court of concurrent jurisdiction directly upon the point is as a plea, a bar, or as evidence conclusive between the same parties upon the same matter directly in question in another court. In India judicial history, we found the beginning of this concept in 1850 in the writing of Macpherson. The term res means thing or matter, and judicata means adjudicated or decided. Thus, res judicata means matter adjudicated or thing or issue before the court already been decided between the same parties. The court will dismiss a case which another court has already decided between the same parties on same subject matter. The objective of this maxim is to prevent the abuse of law. The concept of res judicata can be found in the section 11 of the Code of Civil Procedure. The silent feature of the res judicata are: 1. The subject matter of the subsequent suit should be identical with the former suit, either actual or constructive. 2. The case must be finally decided between the parties by the competent court. There are two concepts of res judicata: 1. Claim preclusion, and 2. Issue preclusion. The issue preclusion is known as collateral estoppel. Once the subject matter have been adjudicated on merit by the competent court, the parties thereto cannot sue again. The basic difference between the res sub judice and res judicata: 1. Res sub judice is applicable where the trial or inquiry is pending, and whereas in the matter of res judicata the case is decided. 2. The res sub judice, the decision is pending or matter under the judge, but in res judicata judgment already passed. Some of the landmark judgment: 1. MSM Sharma versus Dr. Sri Krishna in 1960. 2. Iftikhar Ahmed versus Syed Meherban Ali in 1974. 3. Ajay Mohan versus H.N. Rai 2008. 4. PVN Devaki Amma versus PVN Kunni Raman Nayar 1980. The res judicata is applicable in all writs except in the writ of habeas corpus. Rule of res judicata is similar to the rule of estoppel to some extent. On the basis of the interlocutory order, the res judicata cannot be applied. In common law jurisdiction, the principle of res judicata can be proceeded by the judge or defendant. But in the civil law jurisdiction, the scope is narrower. The concept is also found in the principle of international law under Article 38, Clause 1, Subclause C of the International Court of Justice Statute.